I thought that Hank Brennan, well, first, this is just a public service announcement to your audience. No one should ever listen to Hank Brennan on 2.0 speed. It's traumatic in the extreme, and that's what I do when it is. It's it's very it's going to take a few days for me to recover. I'm going to have to listen to him on normal speed moving forward. But substantively, I will say I thought he was an asshole to Wolf and Rentschler. I will commend him in that he gave an aggressive cross-examination. I mean, lawyers aggressively cross-examine. They should. Not all of them do. And it's a skill, but there's a difference between being aggressive and being an asshole. And he breached that threshold real quick. And then to listen to it on 2.0, it was a little rough for me. And I will say on this point that Judge Bev was letting him have free reign on objectionable questions, interrupting the witnesses with his snarky little, editorializing, mischaracterizing questions and answers to questions where he seemed to think that Wolf wasn't giving him the answer he was looking for. So I found that to be very unprofessional. And this is a preview for how some defense experts will be cross-examined at trial. Other than, I will note, I don't think Hank will be as much of a jerk in front of a jury. He better not, because that's a surefire way to get a jury to hate you beyond the current state, which they probably already do. So, yeah, I still think, though, ARCCA is going to be allowed in.
Man, if you were going to hire me to be your use of force expert, wouldn't you want to know my rate of pay? Wouldn't you want to know the scope of work that I'm going to be doing for you in servicing your client?
That's would.
Practice.
I absolutely would. And also, there are, I go from my own experience. I've had multiple conversations with experts that have been 30 minutes, an hour, where we're just talking about logistics. I mean, I had to fly an expert from Washington State all the way over to New Jersey, and I'm very hands-on as a lawyer. I don't like to delegate that to paralegals and secretaries, administrative assistants, as they should be called now. I apologize to my assistant when I say that. They should be talking about logistics, rate of pay, how it normally works, the retention expectations. And then you throw on the additional factor here, which is nobody knew the rules of the game. This is such an uncharted territory. It's like, you're not our experts. The Department of Justice is the entity that controls you and has engaged you. What can we talk about? How do we get you here? So I found nothing nefarious about the length of calls. I also find nothing nefarious about the absence of text messages now or written communications at this point. But when a witness like Dr. Wolf, because nothing truly substantive came from Rentschler, when a witness like Dr. Wolf comes into court and gives sworn testimony that is unrefuted, okay, Hank can't refute it. He didn't present anything to refute sworn testimony. He just grilled Dr. Wolf. So when an expert like Wolf comes in and gives his testimony, which I found to be credible, and I don't think I'm alone, then the judge should take the expert's testimony at face value, give him and the defendant the benefit of the doubt. She's already talked to and elicited at least statements from Alan Jackson about what he did or did not discuss with the expert. There's been pleadings submitted about it, although I haven't seen them in weeks. So I feel like there's no reason to bar ARCCA at this point, because you have the expert come all this way to say there's nothing there. So the fact is, she better make a decision soon, because when she kind of put it to Rentschler and Wolf at the end, like, can you get your I guess it's a supplemental report or some
Yeah.
type of
I've been
encapsulation
waiting for that. Yeah.
or new experiment. Can you get it to me before May 7th? Well, she damn well better be letting them in, because I would be really pissed if I was Karen and her team if they're having experts put things together on a very short timeline. It's going to cost a lot of money. And then to have them barred thereafter would be a complete waste of everyone's time. Most judges would make a decision based on what they saw today. She's heard enough, but she's going to sit
She's
and
heard it before.
yeah.
We've been through this already. And we,
Yeah.
and like,
a
go
big
ahead,
difference
Todd.
now. A big difference now is, when either side in the first trial could have engaged the ARCA experts, and the
Yeah.
defense took advantage of it because of obvious the science behind their testimony was favorable to the defense. Now, where the defense is actually engaging them, there's something called trial prep,
You're
because
right.
obviously they're going to trial. The trial started, and here they are, day 5 into this thing, still trying to sort through this stuff. Defense is well within their right to prep their experts in
Yeah.
order to bring their level of expertise to support the defense.
I agree. And it's actually kind of hard, in my opinion, for Wolf and Rentschler to kind of surgically extricate what they've done now with the defense versus what they did back then. Because, once you know something, you can't unknow it. So I imagine it was a little challenging for them over the last few weeks to kind of say, okay, wait, let's hit pause, let's rewind. What did we do a year ago versus, I mean, they've rolled up their sleeves. They're in the dirt with Alan Jackson and team now. So it just seems to me like if the Commonwealth, and I was happy to hear that it was emphasized several times affirmatively by the ARCA experts, if the Commonwealth had free reign and access to ARCA all along and chose to put blinders on and ignore evidence that they presented that the government of the United States felt was going to be substantive and dispositive, but the Commonwealth doesn't want to hear it. I feel like it's like dealing with my children when they were little, and they would just put their hands over their ears and say, no, 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 I don't want to hear it. I don't want to hear it when mommy says it's bedtime. No, the Commonwealth ignores the fact that ARCA exists and goes out of its way to just knock it out like a game of dodgeball. And I really, truly hope, as someone who's put a lot of time into my legal career, that the net result is this is a big waste of time and money. I mean, it's a shame that Karen's team has to expend it, but the right result would be to let them in. I still think they will be let in without any limitations.
Yeah, the bottom line is this, Nan, and I'm going to kind of piggyback over because this is what's been in my head here. The bottom line is this: ARCA came up with a report that essentially is favorable to the defense. Okay, the Commonwealth had their opportunity to go in and speak to them, and we heard it from Wolf multiple times today. I told you before, the Commonwealth Wolf said right to Brennan today multiple times, you had the opportunity to engage us and you didn't want to. Because you know why they didn't want to do that, Nan? They didn't want to have to explain and break all this down because the science is there that proves Karen Reed never hit John O'Keefe and John O'Keefe never came in contact with Karen Reed's vehicle. So to challenge that, it's going to be extremely difficult for the Commonwealth. They didn't want anything to do with it. So they pushed it aside and they hoped that it would all go away. But again, it's a piece of information that is very favorable to the defense. Why wouldn't you engage them? And I saw today, when I saw Hank Brennan today, throwing his hissy fit in court, he knows all the motions that he has been filing all along, going back to even in the hearings, the pretrial hearings, and not getting his way in here. This was an opportunity for him today to grandstand in front of the world because all eyes are on this trial. outside the presence of the jury. And I said this to Todd. I said this to Todd before you jumped on. It's funny watching his behavior when a jury is around. And we talked about this before, and how he will be outside of the presence of the jury. This tough guy, Whitey Bulger mobster guy. I'm going to lay into, Dr. Wolf, and we'll play a little bit here in a second. But again, that's why they didn't want to engage ARCCA. They knew that it would take a mountain of information to try to twist this and spin it, because it just proves it's science. It's all there, and it's science, black and white data. You're not going to make it go away.
Oh, I 100% agree with that. I felt like right from the jump, Brennan was coming right out of the corner of the boxing ring. He went into this, fit to be tied. I was overly aggressive, and it's an art. You have to be able to know what you want to do, be firm, listen to the answers you're getting, but don't be a dick. Pardon my French, but just don't be a dick when you're trying to grill someone, because it really it came off poorly to me. And the other takeaway is, how many times did it come up today that the Department of Justice, where the feds were watching trial 1.0? I'm telling you guys, and I think where I stand. Like, I do not believe that the federal investigation is over. I do not. And if they were watching trial 1.0, as was confirmed by sworn testimony today, I will assure you they're watching 2.0. I'm sure they were watching today.
Todd, any follow-up on the feds? Let's hear from you.
Yeah, without a doubt. It might not be active as far as interviewing witnesses and going out, but doesn't mean that their eyes are not on this 2.0. Does not mean that at all.
You can't tell me that there's not a desk agent that's sitting there watching this trial, taking notes or taking transcripts of this. I mean, most certainly. We have a dead police officer. There needs to be answers for that. And certainly the evidence shows here that Karen Reed didn't do this. So that circle outside of Karen Reed has a lot of answers, in my opinion, a lot of questions, in my opinion, to answer for. He's even heard this today. Microdots put out a tweet today and said, Wolf confirms Department of Justice was closely watching the entirety of the first trial, and ARCCA had a direct line of communication with them, and the feds were giving ARCCA information throughout the trial. And Microdots asks, do you really think that the feds have lost interest in this case? No. And anyway, when has the feds ever said that, they're going to just publicly come out and say, oh yeah, we're just, we've just ended the investigation? They're not going to say anything to the public.
I'm telling you, they don't say that. They don't.
Not how they work.
No. So it's interesting. And I did not have a chance to really be active on social media today, but that's great that Microdot said that. Yeah. Because they're watching. So, and they're watching Bev too. And Bev gave Hank way too much of a long leash today. Even you could hear Alessi, objection, Your Honor, objection. Like, it's unusual for the defense attorney or the attorney who's propounding the expert, putting forth or proffering the expert, to be objecting that much. If Alessi, who is a skilled litigator, is objecting as much as he was, that is an indicator to all of you and those watching on replay that the questions were problematic. The style and the approach was a little, if not a lot, too much.
Yeah.
There were times when he didn't even acknowledge the objections.
Yeah. He just kept going. And also she would say, Todd, she would be like, everyone should listen to this, because when an objection would come in, now she's got a new tell, and here it is. She will say, objection as to form, or excuse me, sustained. Pardon me, it's been a long day. Sustained as to form, and normally that's not been her par for the course. Normally she'll just say overruled or sustained. Now she is signaling to the Commonwealth, rephrase it and I'll let you say it. Now she did that occasionally in 1.0, and she's done it occasionally in 2.0, but now it was like almost every question when she was sustaining, meaning agreeing with the objection, she would coach Hank and then let him re-ask the question. Improper. Shouldn't happen. So
Lally,
I
you're
have
saying
my
Lally.
answer.
1.0 was Lally. Yeah.
Yeah. Oh,
Yeah,
excuse me, Lally. I apologize.
Yeah, I mean, we forgot about him. He's not around. We saw him the other day. I said, I was out to dinner with Todd last night. I said, it's funny. We got to see Lally. I mean, he's been kind of silent for the last year. I said, jokingly, I said, you know, I kind of miss the old bugger not being up there.
Yeah, he's. In fact, that's true because I put something out. I'm like, has Lally risen? He's risen, and Plevin dished it back at me, and we had a little tete-a-tete. Although I haven't been on social media much today, but seems like a lot of the camp, the other side, has been awfully quiet.
Very quiet. Yeah, very, very quiet.